Today's webinar is ADA Online, a 2023 Web Accessibility Legal Update. Today's speakers, John Egan and Jason Taylor. Jason Taylor is Chief Innovation Officer here, and I'm going to go ahead and hand it off to Jason now for intros and agenda. Jason?
Thanks, Bethany, and thanks everybody for joining us. I'm really pleased to have John with us and from SafePath. And I actually wanted to start maybe with John, if it's possible, to give us a little bit of a background of yourself and SafePath and your practice in this space of digital ADA lawsuits.
Sure. Thanks, Jason. Hi, everybody. I'm very pleased to be with all of you today. My name is John Egan. I am a partner at the law firm Seyfarth Shaw, based in New York City. I'm part of the Labor and Employment Department of my firm, but my exclusive focus is all matters accessibility, as well as the Americans with Disabilities Act. I counsel and defend places of public accommodation, housing providers, and employers in connection with all manner of accessibility cases, including those of a digital nature. For 3 years, I'm proud to say that I chaired the New York City Bar Association's Disability Law Committee, where I routinely interface with members of the court, judges, advocacy organizations, defense firms, and a wide range of accessibility stakeholders on matters of importance in New York City. I handle these sorts of cases, digital, physical, and other ADA matters nationwide, and I've had hundreds of website accessibility engagements, including ones where I've had the opportunity to partner with UsableNet, and I'm pleased to be with all of you and with Usable today. Thank you.
Thank you, John, and thank you for being with us. If Bethany, if we could look just at the agenda. We wanted to keep it simple today. The first thing that John and I are going to do is give you a sort of a background of like how we got here. And what I mean by how we got here is essentially, why are companies, websites or apps being sued and generally being sued under the ADA. So we're going to talk a little bit about the history about how we got here. And then John's going to basically take over because it's quite active right now in the legal space. So he's going to give us updates on sort of what legal actions are happening in this space that could potentially be bringing some relief or some clarity to businesses. And then we're going to end with hopefully some practical takeaways of what you could be doing to immediately improve the accessibility of your digital properties, your websites and apps. And at the same time, reduce your risk against receiving some type of legal action around accessibility. So let's start with the background. Just to sort of level set, John's going to give us a brief history of the ADA and essentially how websites and apps have been attached to the ADA, and the ADA is now used as a strong means of bringing lawsuits in this space.
So we're talking today about public accommodation accessibility, particularly under Title 3 of the ADA, which would be the applicable title. Of course, the ADA, the groundbreaking landmark legislation dating back to 1990, requiring that, among other things, places of public accommodation provide equal access to their goods and services in various elements of American life. There are various buckets of obligation, buckets of accessibility, which I've described for you here. One is physical accessibility, the requirement that places of business, public accommodations, which are publicly facing retail stores, places of lodging, schools, professional offices, one of the 12 covered categories of public-facing business, whether they have accessible facilities, their obligation to reasonably modify their policies and practices to ensure equal access. And then thirdly, the topic of focus today, the obligation that public accommodations provide effective communication to individuals and with individuals with disabilities. And they do that by providing free of charge auxiliary aids and services to provide effective communication. And so this gets to alternative methods of communicating with folks with perceptive disabilities, disabilities of sight, hearing, speech, cognition, the obligation that that business alternatively communicate in an effective way. Digital accessibility is a part of that requirement. In terms of remedies, what happens when you violate the ADA? Well, there's a couple of different components. The plaintiff, the individual bringing a lawsuit, can recover the full measure of their reasonably incurred attorney's fees if they are successful. They can obtain an order from the court directing the covered entity to end the discrimination and make its facilities accessible or address the particular barrier at issue. And while there's no damages per se available under the ADA, in various states across the country, such as New York and California, there are compensatory and statutory damages available to plaintiffs who prevail, where they can show that they were, injured through emotional distress or otherwise by a barrier. Not only can individual people file these claims, but the Department of Justice, an entity we're going to talk about a lot, can file an enforcement proceeding against covered entities, and they can recover damages as well as six-figure penalties can be issued as a result of a DOJ investigation, as well as a directive by the agency, the enforcing agency, to redress discriminatory conduct.
That's great, John. And if we bring up the next slide, because John just mentioned the importance here of the Department of Justice, of the DOJ. And it's really important to understand how we got here. As John mentioned, that the ADA was written 30 years ago. There were no websites, there were no apps. So it's been the Department of Justice which has really added the color to their belief that where you trade business, whether you are selling things, whether you are providing orders online, whether you're providing banking online, it's really DOJ has over the last 20 plus years sided on saying that they are places of public accommodation too. There's nothing written in the ADA specifically about websites or ADA or apps, but it's important to understand that the DOJ over the last 20 years has built a very strong case law and sort of settlement situation to apply its belief that essentially places of accommodation include websites and apps. And the graph that we have up basically is sort of trying to demonstrate why we have so many lawsuits today. So the chart basically shows the activity of the DOJ over the last 20 years and then private lawsuits over the last 20 years. And the graph basically illustrates that the Department of Justice was very active between 2000 and 2016, siding on the side of plaintiffs. Those plaintiffs were typically advocacy groups like the National Federation for the Blind. They were typically aimed at organizations that did very significant things like banking or H&R Block or education. And the Department of Justice believed that it was important to establish that those online worlds were part of the ADA and the requirement to do it. John will go into a little bit about what they perceived is accessibility and what that needs to do. But what's important is that for 20 years, the Department of Justice pretty much has sided on the idea that websites and apps are part of the ADA. But in 2017, they stepped back from legally adding specifications and different requirements under the ADA Title III, and sort of and private law firms took over. And I wanted John to talk about that. The graph basically shows that before sort of 2016, there were no real a lot of private cases which didn't involve the Department of Justice. That grew from about 800 in 2017 to this year, probably somewhere north of 4,000. So I wanted John to explain how is the plaintiff bar sort of leveraging the history of the DOJ's position to bring this many lawsuits?
Right. So I think it's absolutely correct that in many ways the DOJ's enforcement litigation established a template really for plaintiffs' lawyers to take advantage of in terms of filing very large numbers of lawsuits in federal and state court, sending out countless demand letters that follow a very similar format and that don't necessarily take a lot of individualized work to churn out. And so, the DOJ has taken the consistent position, I think, that websites need to be accessible, that the WCAG, Web Content Accessibility Guidelines, are a measure for that. We're going to talk a lot more about that. But that really seeded an environment whereby the plaintiff's bar could file very large numbers of cases using a similar kind of approach. And that is, I think at core, a legitimate question, which is, okay, more and more commercial activities are shifting online. And how are businesses going to provide those services on an equal basis to individuals with disabilities along the requirement of providing effective communication? And that's at the core of this whole thing.
Yeah. So if we look at what a typical legal case looks like today, right? A typical claim. So as I said, this year, probably about 4,000. So we're talking around about 100+ cases every week right now. I think it's important for people who are new to this. This is not 4,000 individuals that have struggled with 4,000 different websites over 6 months and communicated with the owners of the website and essentially got frustrated and hired 4,000 lawyers. This is typically a activity around a very core group of plaintiff firms and plaintiffs. So as John said, most of these claims have a sort of formula to them. They will be brought by someone who is blind, who uses a screen reader. In typical, they will most likely they will be targeted at a website. Most likely they will the claim will make a claim that the user could not achieve something that other people could achieve. Sometimes that's documented with screenshots. And there will be reference to issues that are found on the website that are non-conforming to the WCAG that will be added to the complaint. And there might be reference to things like if they use a technology that they feel is not appropriate, like widgets, which are hard to use for screen readers, or the lack of accessibility statements on websites to say that basically the company has no plan and is discriminating against. But I think the important thing to talk about, and maybe John could give his perspective on, 80% of these are brought by the top 10 plaintiff firms, and they probably represent no more than 20 plaintiffs. So John, maybe you could talk about, what do you see that as being? Is that aggressive advocacy, or is that opportunistic work from the plaintiff bar?
That's a great question. I mean, I always try to separate in my mind, the various sort of groups that are, have an interest in this on the plaintiff side. I mean, you have advocacy organizations like the National Association for the Deaf and some of the institutions that you mentioned that are, redressing, issues on behalf of their membership. They're not filing hundreds of cases, right? They're more selective in what they file. We have agency action. We have the Department of Justice. We have the United States Department of Education, which is very active, which is pursuing a regulatory agenda and an enforcement agenda. You have individual people, right, who have screen readers and want access. And then you have the lawyers that file the thousands and thousands of claims. So I try to keep it separate in my mind. I find that some clients have a difficult time doing that because it's sort of unsavory, the prospect of getting hit with a lawsuit that's very similar to one that was filed against, another person or individual in your, in your industry. And so there's a lot of pushback and a lot of bad feelings when these lawsuits are filed. So the bottom line is dealing with that serial litigant, as we call them, category, which is not the same as everybody else I just mentioned. Yeah, it's a small number of plaintiffs' lawyers that are filing high volumes of cases that are very much settlement driven. So very few of these cases have went to judgment. Very few of them have been, tried because they provide, I think, for the lawyers that are filing them, an opportunity for a relatively, stable recovery in the form of a settlement. And quick.
Yeah, no, I mean, I hope what we're trying to do here is sort of paint a picture for people to understand why certain trends exist in this space. And then finally, one of the things that we do is we track all of these cases and we produce a lot of trends. And Bethany can actually include a link to our current report. We produce 2 reports a year on all the trends in this space. We only track lawsuits which are aimed at websites and apps, and you'll be able to see those trends and some color that we talk about. One of the big items is that e-commerce is #1 target. Over 80% of the lawsuits involve some type of e-commerce. I'm going to get John to give you that his legal reasons why. I'm going to give you the technical reasons why. As John said, this is in the case of 80% of these lawsuits, it's a process. So it's a volume. So the first is you need to start with a volume, and e-commerce is where you've got lots and lots of websites, right? The second thing is that it's probably quite easy to find problems on e-commerce because they're complicated. They're changing all the time. So technically, it's hard to keep up. It's a lot easier for a plaintiff to find issues, document those issues. Also, probably easy to find issues that have been missed under the WCAG. So easy to create a list to add to that sort of lawsuit. And I'm going to get John to talk about why he sees maybe e-commerce is easier to argue in front of a judge, why it's important. I just wanted to give one last thought about e-commerce from a technical perspective. Is that with the fact that it's changing all the time, it's very hard for companies to keep up. Plus, a lot of this is actually built by other people. It's not actually the company themselves. They paid someone to build it, and a lot of time that means that someone else. The company might think someone else is responsible and it isn't keeping up with accessibility. So John, maybe from a legal reason, why do you think e-commerce is the number one target?
Well, when you see the complaints, they follow a very, typical pattern. I went on this site, I tried to buy this, I couldn't because I encountered, a barrier. And then either that'll be articulated with some degree of detail, or rather you'll just see a very similar recitation of all the things that, all the WCAG highlights. And so, that concept of, all right, find a product, put it in the complaint, recite all the barriers that are, everywhere on the internet, has, I guess, been a profitable course. There are many of these e-commerce providers. I feel that although I don't file cases against businesses under 88 Title III, I do feel, based on the number of cases I've handled, that there is an interest in finding defendants that have been sued for the first time. Those cases tend to, resolve earlier. And I think if you are going after a big box store that's, invested significant sums in a digital accessibility consultant, in an auditing protocol, which we'll talk about, it becomes a different value proposition to settle those cases up front, and there may be more interest in actually going to the merits or pushing back. And so they appear to be a less attractive target for my adversaries in this space.
Yeah, so I mean, there's good news and bad news. The bad news is that there's a reasonably well organized group of plaintiffs and plaintiff firms which are looking for volume of lawsuits, right? So that's the bad news. The good news, and we'll come back to this at the end when we start talking about practical, is we don't believe, and John, maybe you could confirm, we don't believe that they spend a lot of time building these cases. So essentially, if you can understand where they're focusing their efforts, if you start doing that to start with, at least you're going to start to reduce yourself from one of the most targeted companies to potentially not looking that interesting because they can't find the types of issues that they're looking for on their website. So as I said, typically that's a blind user using a screen reader. That's testing all the pages with for WCAG issues, which are easy to find, so they put them in the lawsuit. If you can address those quite quickly, you're more than likely not going to get a lawsuit compared to if you don't address them. And actually, I think that brings us on to sort of like, what is the accessibility items that you should probably start thinking about today, right? So I would encourage you to, if you've never done any accessibility, I would encourage you to find someone who's a screen reader user and ask them if they can do the things you expect them to do. Low vision contrast colors are things that are easy to make mistakes on with regard to design, but they're easy to actually check. So again, making sure that your designers and the people who are putting content on the website check any of your contrast colors in terms of text on background, for example, right, and make sure they're okay. Captions onto video files and audio files, these are again reasonably easy to do, but if they're not there, they're very easy to point out that you haven't done. Simply trying to use your website with a keyboard. That's how screen readers use websites. So even if you don't have a screen reader user, if you actually ask your technical team, can they use your website just using a keyboard, get rid of the mouse? That will give you an indication of if you have major issues on a website. If they can't get through your website buying something using just a keyboard, which means that they're navigating with tab and return rather than using a mouse to get around, then you know you have major issues. And again, colorblind is really removing color as any indication of navigation. So for example, click the green button as an example would be a colorblind issue with regard to someone not being able to see green. So most of these things are technically simple, but they're easy to miss. If they're easy to miss, they're easy to find, they're easy to put into a lawsuit. And that's really the bottom line that we're seeing today. So, there are things that you can do that will help you. Now, what would also be really useful is the law becoming a lot more clearer for businesses about what they have to do by when. And now that really puts me into John's world of like, what is going on right now in the legal space to bring some of this clarity that I think most businesses are looking for, John?
Yeah, so in terms of standardization, there are a few federal laws that have incorporated the Web Content Accessibility Guidelines, which are promulgated by the international organization W3C. And this slide tells you, some information about those criteria. The primary websites of airlines under the Air Carrier Act have to be WCAG version 2.0 AA conformant. This is the standard for answering one of the questions that came up. This is the standard for federal agency websites that they comply with 2.0 AA of the WCAG. There are 3 gradations of success criteria. Single A would be like sort of basic stuff. AA would be what's considered a standard. AAA is sort of aspirational, okay? And big news for those of you who work for or affiliated with state and local governments, the DOJ has issued a notice of proposed rulemaking with an actual proposed regulation governing state and local government agency websites, which actually refers to, and granted this is only in draft form, but it would incorporate levels 2.1 single A and double A. I think, okay, next slide. The regulatory timeline. We're going to move through this pretty quickly because we want to stay on task in terms of our timing. But in terms of the DOJ, where did this sort of come from a regulatory perspective? Back in 2010, the DOJ proposed the concept of website accessibility regulations covering places of public accommodation and state and local government entities. They didn't wait for regulations to issue before starting enforcement activities. And you saw that on the prior slide in terms of DOJ enforcement in court. They also commenced numerous investigations, which were necessarily in federal court, but you basically receive a letter and now you're in the process of defending yourself with respect to a DOJ investigation. In 2017, under the Trump administration, the DOJ sort of withdrew from some of this rulemaking priority. Under that administration, you couldn't, if you were an agency, you couldn't pass a regulation unless you withdrew 2 regulations. And so it basically froze the rulemaking process and they withdrew from the prior advance notice of proposed rulemaking. I don't think this had the intended effect because, as we saw on the prior slide, costs to businesses were increased in the form of an explosion of private litigation. In March of 2022, the DOJ issued website accessibility guidance. That guidance isn't all that helpful in my opinion. It just basically references the WCAG. It talks about how how public accommodations have flexibility in terms of how they can comply, but it doesn't really talk about how is that flexibility deployed and how is conformance measured. So those are still open questions following the issuance of that March of 2022 guidance. Next slide. In June of 2022, a number of senators sent DOJ a letter, pushing them on the question of rulemaking, and a number of advocacy organizations have also sent letters to the DOJ asking for rulemaking to be started. So everybody seems to agree on all sides of this debate that regulations are warranted and would actually be helpful for all involved. And then leading up to sort of the present, DOJ started the process for state and local government website accessibility rulemaking. Those rules are out, and the comments are actually due next week. Important to note, in February of this year, the DOJ released a report on its compliance with Section 508. Again, Section 508 requires WCAG 2.0 AA conformance by federal agency websites, both internal and external facing. And the report was very interesting to us because it showed significant deficiencies with respect to the number of websites that are fully accessible within the government's platform, deficiencies in terms of the number of resources that are allocated and the organizational maturity, and issues concerning the testing, whether there was appropriate testing being done in various departments. All these issues were raised, and this happened after 5 years of being on notice of what the requirements were, which raised concerns for how the rest of us are going to be conforming to WCAG in the future. Okay, back to you, Jason.
Yeah, so I mean, just to sort of summarize before we go into sort of some of the more hot topics for John, the best thing that you can do is target the WCAG. It will give you a good path to make sure that you are moving towards conformity. But I would always keep in mind of how do I prioritize the efforts, and how do I prioritize the efforts in terms of where do I want to focus. And then we will talk about towards the end of these hot topics. Many companies, I think, need to keep in mind that they are responsible for their website, but they're paying somebody probably to build that website. So having a relationship where you are where you're able to question to your suppliers, what have you done? Where do we stand? What are you doing to make sure that we are compliant or conforming to WCAG? Understanding whether your supplier even knows anything about this, right? Will give you an idea of how much at risk you are. Making sure that this type of stuff ends up in procurement. So when you're updating contracts, when you're creating new contracts, that you're making sure that this is part of the contract discussion, part of the requirement when you're buying it. Does not relieve you of the responsibility. It's your website, it's your office, right? Essentially, but does give you, making sure that you're using your money as leverage to make sure that you're at least minimizing your risk of these lawsuits.
Okay, so and again, as we talk about the WCAG, important to note in response to a comment that I received, the WCAG sets forth criteria that would provide for accessibility across a range of assistive technologies. So people don't just use screen readers. Sometimes they use, if they have disabilities associated with their ability to use their hands, they have screen readers that, not screen readers, they have assistive technology, okay, that would allow them to, manipulate and browse, the internet. So there's a huge range of the different types of disabilities that folks have. And what the WCAG is aiming to do is to provide a standard by which, if covered entities comply, a range of assistive technologies would be workable with that digital property. So important to remember that. Under the Biden administration, notable was a consent decree for the University of Berkeley's website. I'm not going to get into it in great detail, but there were interesting aspects of it, including, and by the way, a consent decree is like a publicly ordered settlement agreement. So it's an agreement that a judge basically so orders, or that's issued by the agency. And what it basically provides for with regard to Berkeley is not only with respect to their website, but also their massive open online coursework has to comply with the WCAG 2.1 AA. The time frame for compliance ranges from like 9 months to 36 months, depending on the property. And what's really interesting too is that there's an obligation on Berkeley under this agreement that they not only deal with their own URLs, but also to the extent that they're pushing content to third-party platforms like YouTube and Spotify. That stuff has to be accessible. So that's a pretty broad interpretation, isn't it? Why it's notable. One question came up in terms of, accessibility of vaccination portals. This was an area of focus for the DOJ, where they commenced investigations against pharmacies and providers of COVID-19 vaccines, taking the position that those portals had to be a WCAG 2.1 AA conformant, and the agreements reflect that. And then, of course, the state and local government rulemaking, that is basically, to respond to a question, it's a notice of proposed rulemaking. It's not a final rule. The final rule is the actual regulation that will issue after the DOJ collects all the comments, public comments that are now coming in, which are due next week. Next slide, please. Okay, so it's beyond the scope of our presentation to get into really deep, detailed case law discussion, because most of you aren't lawyers. But what we want to do is give you a sense of what are the arguments that have come up in court by public accommodations that have been sued over the accessibility of their digital properties, and what arguments have they made, and sort of what do we think of those arguments, and what are the nuances associated with those arguments. So let's take the first one. Are web-only businesses a covered place of public accommodation? Courts don't agree on this point. And I think the DOJ would say that any website is covered, but courts don't agree because they focus on the language of the ADA done, issued before in the infancy of the internet, by saying, some courts say, for example, in California and Florida, for a business to be subject to one of these cases, it has to have a nexus or a connection between the website and a physical place of public accommodation. So if you're an internet-only business and you're sued in Florida or California, there's a viable defense for you in those jurisdictions. Now, judges in other parts of the country don't agree. Many judges in New York don't agree. Many judges in New England don't agree, and taking the position that the ADA has to evolve with the times. And if you look at the language, an internet-only business would be covered by the statute. And so there's disagreement on that point among federal judges and state court judges throughout the country. Next issue, if you enter into a settlement and you agree to make your website WCAG conformant, are you good? If somebody else comes along, well, maybe it can help and maybe not. It sort of depends. Courts have come out different ways on this. But what some businesses have done is entered into consent decrees as a result of being sued in one of these cases, and had the court so order or endorse a commitment to be WCAG conformant, and then take the position if there's another case that, listen, this is not a viable claim. And courts have come out differently on that question. One key issue is, are you being sued the second time for the same issues that were in play the first time? If there's new issues, you're not quite in the best position to say that first settlement agreement bars a subsequent suit. So it's not a bulletproof approach, but may be helpful. Third, does the process of making your website moot the issues? In other words, can you say, my website is accessible, I'm done? Or are you still on that journey? Generally speaking, if you basically say, I'm in the process of making my website accessible, that's not going to moot the lawsuit. You really want to be there at that point of accessibility by the time you get sued to be in the best possible position. And then fourth, does the individual who's filing a lawsuit, what do they need to show regarding their injury? Let me pause for a second here and talk about legal standing. Legal standing is a very important concept in federal courts, because federal courts are courts of what we call limited jurisdiction. They only can resolve actual cases or controversies. You can't go to federal court and say, I have a theoretical question I'd like to run by you. That's not how it works. There needs to be an individual who was harmed, who was injured. And under the ADA, there needs to be an imminent likelihood of future harm. You have to show that unless the court gets involved, that person's going to be harmed in the future. Okay, so that gets to the question of standing, and we'll talk more about that with the next slide. Big news in the ADA Title III world, which is the Lawford v. Atchison case, which is before the United States Supreme Court. It is the first ADA Title III public accommodation disability case to reach the Supreme Court in 18 years. And it's up for oral argument next week. The issue is, while this is not a website accessibility case per se, but rather involves whether a hotel provided sufficient information on its website about the accessibility of their rooms and common areas, The question is whether an individual has to show an interest in actually going to the hotel and filing a claim, or whether the individual can be what we call tester, somebody who evaluates the accessibility of a property or of a website without actually having intent to use or visit that business or that property. Tester standing, as we say, goes back many years under the discrimination in housing statutes, where individuals of color were permitted by court decisions to test whether landlords and housing providers would offer them housing. So folks would basically call and ask for housing even without an actual intention to rent the apartment. And if they were discriminated against based on the color of their skin or their national origin, then they had a basis to file a claim. And so that concept has been extended in the civil rights world, including with respect to disability. And so the question before this conservative Supreme Court, up again for oral argument next week, is going to be whether an individual can be a tester in that sense in the disability access space, or whether they actually have to show an intention to visit the place at issue, to actually utilize those services. And the individual who filed this claim has filed many, many cases against hotels across the country. And so it's a very pertinent question. And I think that the answer here will impact, and we can talk more about that, website accessibility cases and how they're filed and their prospects for success. Okay, state and local government websites and the proposed regulations. And now again, these are just proposed regulations that would govern state and local government websites. They're not final. I think there's going to be substantial differences between this proposed rule and what ultimately is issued. But and why are we talking about it if many of you aren't involved in state and local government websites? I think that it's a really good indication of where the DOJ is going with not only ADA Title II covered entities, but ADA Title III covered entities, basically places of public accommodation. We expect that there will be regulations in the ADA Title III space, and we expect that they're going to probably be similar to what the DOJ is working on right now for state and local governments. It's very unlikely that there's going to be a really massive change of direction between Titles II and III. Historically, this is how the government regulates in the disability access space. It was the same thing in physical accessibility. First, it was federal buildings, then it was state buildings, and then it was private buildings. And so that progression is what we see happening here. So as I said earlier, this proposed rule would require WCAG 2.1 levels A and AA conformance. It would apply to the website. And interestingly, similar to that Berkeley case we talked about, it would also cover web content that's pushed out by state and local governments to third-party platforms. So to the extent that state and local government content is on another platform and is pertinent to the program, services, and activities offered, there'd be an obligation to make that content accessible. The time frame for compliance would be between 2 and 3 years, depending on the size of the government entity involved, and whether it's a special purpose entity that performs discrete functions. That sort of entity would get 3 years for compliance. It would also, be a pause. We would hope for private litigation. Although, to answer a question that came up earlier on the chat, government entities are not great targets for lawsuits because they're sort of a pain in the butt to sue from the plaintiff's perspective. But it would also cover, discrete files on the website, like PDFs and Excels. But there is a safe harbor for pre-existing files, unless those pre-existing files are pertinent to how the entity delivers its programs, services, and activities. Next slide, please. Defenses, which are really interesting, from my perspective, there would be carve-outs for archived content. And so, if the regulation looks the way it's being drafted now in final form, there would be an opportunity, I think, to archive content subject to certain guidelines that would then be carved out of the obligation to be WCAG conformant. I talked about documents. We talked about third parties. Institutions for higher learning, there are specific, I know a number of you, work for such institutions. There are a number of carve-outs that are applicable to them. They concern whether and to what extent schools would have to make accessible password protected content. So password protected content would be like, the syllabus that you would access when you log in. And the short answer of it would be, you don't have to worry about that unless you're on notice that you have a person with a disability who's enrolled. So for elementary schools and secondary schools, it'd be, the kid or the parent would have the disability that would then trigger that obligation. For colleges, if you're aware that a student, an adult is enrolled, then you would have that obligation then and a time frame to provide accessible content. So that's that sort of provision as well. And again, the comments are currently due on 10/3/23. Other relevant offenses, you can link to an inaccessible website and you don't have an obligation. I mean, that's permitted. And if a third party posts content on your website, you don't have an obligation. Again, posting. So think like message board in a community, in a township, somebody posts a message, posts a video or a photo, that wouldn't necessarily be covered. But to the extent that you have a third party that's sourcing part of your website, you would have an obligation. And so I think about colleges and universities with, for example, athletics websites that are oftentimes supplied by third parties that deal with everything, right? Well, guess what? That would be covered. And you would have an obligation to comply with 2.1 AA if you were a covered entity in that instance. Best practices. Jason, why don't you kick us off on this? This is fun.
Yeah, so John, I mean, I really appreciate the detail that you've given us, and I think it's really important for people to understand that this legal space is constantly updating, and we try to keep people updated on that. This is, we didn't even have time probably to talk about what's happening at state level. There's proposed bills in California. There's other things that happen in different states. Why those state things are important to keep track of is if you do business in California, you're subject to California laws. So if you do sell stuff on your website in California, you're subject to California laws. So I think it's important not to just if you're looking at this from, hey, what am I need to look at in terms of what legal areas do I need to cover? It's not just federal. It's pretty much anything where you do business. You need to make sure that you're on top of with regard to what requirements you need to do. What we wanted to leave with some practical stuff, and I'll go back to the idea that John may have a different opinion, but essentially accessibility is here to stay. That websites and apps are going to have to conform with most likely the prevailing standards of WCAG. They are quite detailed. They are quite hard to keep up with if you've got complicated websites. So I typically would start with prioritization around what you've heard today, around the types of things that are brought in lawsuits, the types of activities that are taken to do lawsuits. And that's not to say that those things are the most important across all of the types of accessibility you can do, but we do want to balance our activity between, trying to basically go all completely accessible and at the same time prioritizing our activity to reduce our legal risks. The first thing there on this sort of list, if you sit down as a team, the first thing you're going to want to say is what standard we want to go to. And John talked about a number of standards that are in different laws. The prevailing standard right now is 2.1 AA. 2.1 AA seems to be the one that's most likely to get you in a good place. The second thing that I would do is start to determine who's responsible for the digital content. This will be different for different companies, but a lot of companies use external companies, marketing companies, web design companies, app design companies, right? So you want to start having conversations with the people that you're paying to make them aware that this is something that you need them to take care of. It's part of their responsibility, and work out how you then potentially make sure that they're doing it, and that you have a way of making sure that they've done what they said they're going to do. That sort of fits into testing and protocols. Like, how do you make sure that content on your website is being updated correctly by the different departments or by external companies that you're paying? Policies, and sort of statements are good because they get stakeholders together, they get the decision makers together. Creating an accessibility statement on your website that you're going to post publicly will have you having conversations with people about what are we going to say, which means what can we do, who's going to do it, who's going to be responsible, where is the budget. These are conversations that need to be had in all the departments. I'd also say that you need to think about, hey, if we're giving people responsibilities, we need to train them. So you need to think about training for the people with responsibilities. And again, that third-party content that John keeps talking about, if you've got functionality on your website, it's your responsibility. So if you're providing booking, meeting, payment systems which come from third party, you need to put pressure on them to make sure that they're delivering you accessible functionality. Otherwise, you will be sued for it. John, did you have anything to add on that before we head off? Because I know we want to keep 10 minutes for questions.
Yeah, let's get to the questions. They're really good.
And just the last slide, just to give you some practical stuff, you'll have this. Bethany will send it. But when I talk about quickly test your website for the easy things to find, we have a free service for that. Go use that on our website. You can test as many pages as you want. You can find a report. We have some great content you can download for free, like a checklist for different departments, what they should be doing. So look out for these 3 links. Bethany will make sure they're in the email follow-up. But these are resources which you can download for free, and they're really good resources to get you started if you've not started already. Back to Bethany to maybe pick out some questions, primarily for John, because we only have John for this particular webinar.
Yeah, I know John was looking at the questions.
I can answer some of them, right? I can team up and answer them if you'd like.
Yeah, go ahead, John. I think you can.
Well, first of all, thanks everybody for asking great questions. As we were going along, I was trying to answer furiously as many as I could, and then those that I didn't answer individually, I tried to weave into the presentation on the fly. But there are a lot of good ones, and I'm going to try to answer as many as I can. One question came up in terms of any news on the California law that would require developers and auditors to be responsible for accessibility. So I think that refers to a proposed bill in the California Assembly that would then, require websites to be accessible to the WCAG, but then would actually apply to, vendors that supply this content, going to the point that Jason made about, procurement and all of that. I think that bill was held back to the Senate Appropriations Committee. I'll try to send that person who asked the question a blog on it, but I don't think that, it's going to make it this year, and it may be considerably revised, in 2024. The bill's concerning because it doesn't have on its terms a compliance period, and it doesn't have some of the defenses that would be available even under this Title II regulation that we've talked so much about. So hopefully the folks in California can take another look at it. So that's the answer, I think, to that question. Other questions that I thought were really great. Do you think that website disclaimers are useful? Are they, or could they be misleading? I think that accessibility statements are great because they're a public recognition that the covered entity or the business is going to make a commitment, is working on it. You provide a method for people to reach out to you if they need help, although that's no substitute for an accessible website. I don't think disclaimers per se are great, but I like the idea of having a statement and an alternative means, of reaching out so that, a person can get help if they need to on a one-on-one basis. So I think accessibility statements are important. And Jason, did you want to pitch in on that question? I don't know if you have a different view or.
Oh yeah, I have a similar view to you. We actually have a blog about what you should maybe consider to put in there. I would generally be like a statement of intention. It's important. It's ongoing. We're doing it. If you find any issues, contact us. I wouldn't get into the details of trying to claim something that then could be quote unquote challenged.
Other question relates to, does the link need to be in the footer on every single company page? Does it have to say accessibility statement, or can it just say accessibility? Can you basically reference that in other parts of your site? I would say yes. I don't think it has to be every page. I think that's a bit much. But I do think that, and I have experience with certain advocates that have taken the position that the accessibility statement needs to be navigable. You need to be able to get to it. What's the point of an accessibility statement if you can't navigate there? So you need to think of it ideally from the perspective of the person with the disability with their assistive technology. And I think it makes sense to have it on the first page, on the homepage. But I think you want to be sensitive to how a screen reader would navigate to it and whether it itself would be screen readable. So that's an important, I think, consideration. Let's see, what other good questions? We have so many to choose from. Okay. Okay, California law. One second. Okay, another question came up about a slide where we talked about this question that's before the Supreme Court on standing. Whether a tester that doesn't necessarily have an interest in, or doesn't express an interest in going to the property, whether they would have standing or do they have to actually show an intention to go. And we referenced this concept of downstream consequences. Now, the reason why the Supreme Court takes cases, folks, is because federal appellate courts don't agree on something. So there needs to be a disagreement among these pretty high-level federal courts for the Supreme Court to actually take the case. And there's a very small number that they actually take. So this concept of downstream consequences is a requirement in places like New York federal courts, where an ADA plaintiff has to show, not only did I encounter a technical violation, but it would impact me. It would impact me, okay? So that means that, because I'm having this issue purchasing this sneaker on a website, now, you have to demonstrate that, you're really interested in that product, that you're going to go back to that product. And it can't just be that I'm just landing on this website for no other purpose than to see if it's WCAG conformant. Like, that's not enough. So those are the kinds of things we talk about in terms of downstream consequences. Okay. Another question that came in. Does a consent judgment in which the company publicly commits to update its website moot a future lawsuit as opposed to a private or confidential settlement? I think that a private settlement, by its terms, is definitely not going to moot a future lawsuit. The question of whether a public settlement moots a future lawsuit is one that really is under debate. I think that there's a good argument to be made. Well, maybe not a good argument, but there's an argument to be made that during the compliance period in the settlement agreement, like let's say it's a year or 2 years, you can go to the court and say, listen, I entered into this settlement agreement. I have 2 years to be WCAG conformant. This case should be stayed or should be dismissed. I think that there's an argument there. Once that period of time elapses, I don't think your argument is quite as good. And I also would want to say to you all, before you enter into these agreements, think about what you're committing to and the resources it'll require and whether it's actually realistic. That's important because these consent decrees have the force of law. I mean, you would violate a court order by failing to comply with it, and that's a serious matter. Okay, let's see. Let's see. Okay, this is an interesting comment, and I think we should talk about it, about automated testing tools. And the commenter basically want to make the point that these tools have limitations in terms of actually dealing with the accessibility of a digital product. Do you want to talk about that quickly, Jason, in terms of testing tools versus user testing with assistive technology?
Yeah, I mean, our general position is you want to do both. You want to make sure that you're at the beginning of the process, you want to make sure that you're testing for everything. So that would include some type of manual review, making sure that the items that you can't find automatically are being reviewed and identified if they're good or bad. Typically, once you get those things in a good place, you could start using automatic testing, on a cadence, with maybe only doing manual review once a year. But you've got to come to a balance of resources, but you can't rely on automatic testing to get yourself in a good place. You need to have both automatic and manual review to identify all the things that are wrong, get your teams to fix those, verify that you got to that place, and potentially you can put in some automatic testing on a monthly basis to sort of make sure that that people who are adding simple content like images and videos and other types of stuff are staying in a good place.
Yeah, we actually demonstrated this, the importance of not just relying on automated testing in August webinar, where we had our head user tester, Joseph Tenero, demonstrate on a website how he navigates. And I'm going to go ahead and close out the webinar.